What I have for you today is a court decision from the High Court of Kenya in the Total Kenyan case, where the question again is whether management fees can be subject to a withholding tax when it is paid from a Kenyan company to a foreign company. And the argument is whether that income is taxable under Article 21, which in the Kenyan treaties follow the UN model, which says that both the residence and the source state can tax other income. And there's a seemingly conflict with Article 7 because the end of paragraph of Article 7 says that any income which is taxed according to an article anywhere else in the treaty takes precedence over Article 7. So let us see what the case is all about. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let us quickly go through the case. The respondent, Total Kenya Limited, is a limited liability company incorporated in Kenya and a wholly owned subsidiary of Total Outre-mer, TOM, a company incorporated and resident in France. Its core business is the sale of petroleum products. We know that. The resident entered into a technical assistance agreement with TOM for provision of technical and general assistance services. We'll just call these management services now. So the structure looked like this, and the payments went from Kenya to France, and the question was, are these subject to withholding tax? And the commissioner issued its objection decisions on these dates, upholding its original assessment, saying there is withholding tax, but the tax tribunal, so this is an appeal case already, allowed the appeal, in other words, reversed the commissioner's decision. Now, if you look at the arguments in the judge's response, the commissioner submitted that because management and professional fees are not dealt with in other articles, there is no article called management fee and professional services, Article 21 of the double tax agreement is applicable. And then we just look at the wording of Article 21. Items of income of a resident of a contracting state wherever arising not dealt with in the foregoing articles of this convention shall be taxable only in that state. This is all the UN OECD models agree on this, but then the UN adds on the back end of Article 21, notwithstanding the provisions of paragraphs 1 and 2, items of income of a resident of a contracting state not dealt with in the foregoing articles of this convention and arising in the other contracting state may also be taxed in that state. And this is where the confusion comes in, because if you now look at Article 7, it's the old style, so the pre-2008 OECD style Article 7, which says the profits of an enterprise of a contracting state shall only be taxable in that state unless the enterprise carries on a business in the other contracting state through a permanent establishment situated therein. So this is very clear that if the TOM company is not in Kenya, it cannot be taxed. But then Article 7.7 says, where profits include items of income which are dealt with separately in other articles of this convention, then the provisions of those articles shall not be affected by the provisions of this article. So it looks, to give the tax inspector some credit, as if Article 21 can set Article 7 aside, because Article 21 does not seem to have a hierarchy, right? But we should not forget that Article 21 says that it only deals with income not dealt with in other articles of the treaty, and Article 7 deals with business income. So if management fees or fees for technical services is business income, then those are dealt with in another article of the treaty. But that's not how the tax authorities choose to read it here. It's also not how they chose to read it in the JP Morgan case, which the judge also alludes to, where the tax authorities also lost the same argument. So it's kind of strange that they take up the argument again, but I suspect that they do it because there are other Kenyan African countries, I think it's Tanzania, but I'm not sure, which do actually allow this line of argument and saying that business management fees can be taxed under Article 21. But I may be corrected here. Feel free to make comments in the comments below. And now we get to the judge's response. First of all, the judge says the definition of business profits is not provided under the double tax agreement. In this regard, Article 3.2 of the treaty says, as regards the application of the convention at any time by a contracting state, any term not defined therein shall have the meaning which it has at the time under the law of that state, under the purposes for the purposes of the taxes to which the convention applies. Now, this is pretty standard Article 3.2 OECD convention. If the term is not defined in the treaty, have a look at it in the national law applying of the country applying the treaty. But there is a difference between the OECD and the Kenya-France case, and that this strips up the case somewhat, because the court goes on to say, reference to section 2 of the ITA reveals that a business is defined as any trade, profession, or vocation, or any and every manufacture, adventure, or concern in the nature of trade, but does not include employment. So this is already very clear. I think that this is how you interpret business profits. But the difference between the Kenya-France treaty and the OECD treaty is that the OECD treaty does have a definition of business, right? The OECD says the term business includes the performance of professional services and of other activities of an independent character. That paragraph did not make it into the Kenya-France treaty, and it may be part of the problem, although having said that, it would only be a partial solution, because if you look at the OECD commentaries to Article 3.1h, it says that, the term business has deliberately been defined vaguely so that you can look at national law for interpreting what business means. But the Kenyan law here is quite clear. Business means business. It doesn't mean employment. If we look at paragraph 34 and further, based on my reading, the judge says of the definition of business under Article 5 and under my understanding of Article 7 and 21, I am in agreement with the holding of the tribunal, and I am persuaded that income from management fees and professional fees fall under business profits, as it does. I mean, France has not performed these services as a shareholder or an investor. They did it as part of managing the total business, right? The Commissioner's argument that management or professional fields fall under Article 21 does not appear tenable to me. I am guided by the UN and the OECD commentaries, good for looking at that, and I am in agreement with the Tribunal's conclusion that the said article was intended for miscellaneous income rather than management income and professional fees. I say so, and I like what the judge says here, because having read the commentary in relation to the said article and looking at the examples of the type of income contemplated in Article 21, professional and management fees appear incongruous, right? You also need to look at the examples given by the OECD and by the UN and try to put them into a specific context, which doesn't seem to match professional and management fees, because it includes things like damages for unfair dismissal, etc., etc. So if we go on and see what the court then says, it goes to Article 7. It says, additionally, the commentary on Article 7 of the OECD Model Convention in paragraph 77 of the commentary is, to my mind, clear and expressed in terms of the effect of the deletion of Article 40. Based on the plain reading and the ordinary natural meaning of the words used, like the Vienna Convention on Law of Treaty says we must do, I am persuaded that the effect of the deletion of Article 14 is that income derived from professional services is now dealt with under Article 7 as business profits. I have also considered the respondent's contention that Article 21 of the DTA may take precedence over Article 7. I do not think there is any basis to the said argument, because no such priority has been expressed in the commentary of the DTA. Moreover, Article 77 of the commentary of Article 7 specifically covers management fees and professional fees. And you cannot just read Article 21 the way you want to. You can't just say, oh, it applies to other income. You gotta say it only applies when other articles have not covered that income in the treaty already. In other words, Article 21 does give precedence to other articles, because it says it only applies if the income is not covered by the other articles, such as Article 7 already. And as the judge says, management fees and professional fees are mentioned in the Article 7 commentaries. The above paragraph 39, the above interpretation has been upheld in jurisdictions beyond our own, and then the judge refers to an Indian case, and I'm sure there are many other cases that he could refer to as well. And so the judge in paragraph 48 comes to a conclusion. He says the court is of the view that a double tax agreement ought to be read and interpreted in a manner that supports its objectives and purpose. Totally agree, which includes encouraging cross-border trade rather than stifling the same, and resolves dispute concerning interpretation of the WTA in a manner that promotes dealing with common tax concerns on the field of international juridical double taxation in a similar method. And the judge refers here, I believe, to common interpretation, as we have discussed in the Fothergill case and as we have discussed in the Indian concentric services case, and which is, if you read Klaus Vogel's book, common practice in international tax treaty interpretation, to steer towards a common interpretation of common issues. So the court is really very good in what it concludes here. And then I just want to show you what the UN Article 14 says, because the UN Article 14 doesn't help the tax inspector, I believe. It says, income derived by a resident of a contracting state in respect of professional services or other activities of an independent character shall be taxable only in that state, except in the following circumstances, right? So it would only be taxed in France if Article 14 was there, except when such income may also be taxed in the other state if he has a fixed base regularly available to him in the other contracting state. So now you've got to take two hoops. You first have to accept that Article 14 also applies to companies, even though it seems to only refer to individuals. And there are countries which believe that Article 14 also applies to companies. So we'll take that jump. But you must still have a fixed base, which is a permanent establishment, or if his, read Tom's, stay in Kenya is for a period or periods amounting to or exceeding in the aggregate 180 12 days in any 12-month period. Now, the way I read this article, it doesn't mean that you can provide the services from France for more than 183 days and then become subject to tax in Kenya. It's only if you provide the services on behalf of Tom from Kenya that you become taxable at all. So I don't think Article 14 would have helped the tax authorities, even though the paragraph 2 says the term professional services includes specifically, especially independent scientific, literary, artistic, educational, and teaching services, as well as independent activities of physicians, lawyers, engineers, architects, dentists, and accountants. So the judge then does say, Kenya has a number of other treaties where they use the UN Article 12, and they also refers to another UN model convention, but those articles are not in the France-Kenya treaty, so you cannot apply them because that is not the treaty that you are applying, right? So paragraph 43, the judge said, I find it useful to reproduce the commentaries of Article 12A. Article 12A was added to the UN Model Convention in 2017 to allow a contracting state to tax fees for certain technical services paid to a resident of the other contracting state on a gross basis at a rate to be negotiated between the contracting states. Under this article, a contracting state is entitled to tax fees for technical services if the fees are paid by a resident of that state or by a non-resident with a permanent establishment or fixed base in that state, and the fees are borne by the permanent establishment or fixed base. It is not necessary for technical service to be provided in that state, right? But this Article 12A, as I said, is not in there, and Article 14 does have the requirement that it must be provided in the state. Fees for technical services are defined to mean payments for services of a managerial, technical, or consultancy nature. So they would have been covered by 12A if there was a 12A. Until the addition of Article 12A, income from service derived by enterprise of a contracting state, such as Kenya, was taxable exclusively by the state in which the enterprise was resident, which is France, unless the enterprise carried on the business through a permanent establishment or fixed base in the other state. Article 5.3b of the UN MTC similarly allocates taxing rights to the source states for services performed over a duration of time. The respondent submitted that Kenya has adopted the said article in DTAs with numerous other countries, including Mauritius. Very interesting, but not relevant, because Article 5.3b is not in the Kenya-France treaty, and that is the applicable treaty. But for us, it's interesting to see what Article 5.3b says. So the term permanent establishment also encompasses, and then you've got letter A, which deals with building sites, and then letter B, the furnishing of services, including consulting services, by an enterprise through employees or other personnel engaged in the enterprise for such purpose, but only if the activities of that nature continue within a contracting state for more than 183 days. And again, I think even if the treaty included in Article 5.3b, it would not have helped the Kenyan tax authorities in this case, because I assume that the TOM employees providing the management services did so from France and didn't do it from Kenya. And one could also ask, what is the difference between Article 12A of the UN treaty and Article 5.3? And the difference is spelled out in the commentaries of the UN treaty to Article 12A and to Article 5.3b, and it simply says 12A is a withholding tax on gross income, but if you fall under 5.3b, then 53B applies and you are taxed like you have a PE, which means you're taxed on net income, not gross income. And Article 12A says we are not applicable in that case because you have a permanent establishment. I think this is an interesting decision. There's one limitation to the decision, which is interesting, but probably not very relevant or won't change the outcome of the court case. But I mention it for the sake of completeness, and that is in paragraph 20. The judge writes, he says, I've also considered the grounds raised in the record of appeal, and I note from the outset that the same does not indeed contain some grounds that were never raised or pleaded at the tribunal. I am of the view that the same may not be raised for the first time before a higher court on appeal. So the judge says, okay, so the tax authorities came with a number of arguments that I'm not even going to look at because they were not made before the tribunal, and therefore I will not apply them. And I think this is interesting because the question is, would one of these arguments have helped if the judge did consider him? I don't think it would have. The taxpayer also complained about these, but they didn't complain about the same ones that I'm listing here. The fifth argument of the tax authorities was that the Honourable Tribunal erred in law and in fact by relying on the provisions of the Kenya-France double tax agreement, which relates to treatment of income and have nothing to do with the treatment of expenses. I love this argument. I mean, the tax authorities are creative, right? Even though the commentary is very clear that, you know, income means costs and profits means losses, they do give it a try and they say, you know, the treaty is only for income, but we're talking about the cost of the Kenyan company, so the treaty does not apply. I don't think this argument would win before any court anywhere in the world, but it is a creative one. And then paragraph 7, that the Honourable Tribunal erred in law and in fact in failing to consider and determine on whether withholding tax regime for management professional services is provided for under the Kenya-France double tax treaty. Again, I think it is a bit of a chanceless argument because Article 2 of the treaty is very clear that, you know, it is income taxes, withholding taxes, and any like taxes, also later introduced, etc., etc. But again, you can't blame the tax authorities for not trying. And then paragraph 14, that the Honourable Tribunal erred in law and in fact in failing to appreciate that the import of the deletion of Article 14 of the OECD Model Convention and in the addition of the term business under Article 3 of its commentaries in relation to the dispute at hand. And again, as I showed before, I don't think this is relevant because also under Article 14 and 53B, you would have needed a fixed base in order to be able to tax the management fees in Kenya. I hope you enjoyed this case. We will discuss another case soon. I might add some technical videos, not dealing with case law, but with Pillar 2 and with other recent international developments in the meantime. But I think these cases like this help us to keep on our toes, because never assume anything when it comes to how foreign countries may tax income. You know, we are used to reading the words of the treaty in a particular manner, but it doesn't mean that that is the only way in which the words of a treaty can be read. Bye for now.